I want to talk to you a little bit about, Richard went through the history of how Article 5 was written. I want to get into more of the nitty-gritty nuts and bolts of how the protections around Article 5 actually work. How do we know that not only theoretically is this limited, but how do the limitations actually get enforced? And the brilliance of the system that our founders created was the system of checks and balances and separation of powers that they designed. There are some very specific safety measures that they wrote directly into Article 5 itself, but there are quite a few safety measures that come out of the fact that they gave different powers to the states, to Congress, to the courts, and to the delegates, and that all of these groups have to work together as well as against each other in order to ensure that we don't get a runaway Congress. We don't get runaway states or runaway courts or runaway delegates. Every one of them has a check on each other, and I'm going to go through each of those, and a few of them I'll give you a little bit of detail, and hopefully we'll get through some more detail in the questions and answers afterwards. By the way, I refer to this as the safety net of Article 5 because of the way everything holds itself together. So first we're going to look at the checks that the state has on each of the other groups. The check that the state has on the states is ultimately ratification. There have been 6 amendments sent by Congress to the states that the states have not ratified because the states ultimately, some of them were pretty popular, but they were not popular enough. Some of them weren't popular at all. Congress hasn't always done a good job with that. But the states have the ultimate power. 38 states to ratify is an enormous bar. Even the Equal Rights Amendment, which was very popular, didn't meet that incredibly high threshold. That's the ultimate check that we know we can't get something that isn't extremely bipartisanly popular among all the states. One legislative body in each of 13 different states could kill any bill or any amendment by simply not bringing it up for a vote. Next, we have the application process. Now, a funny thing about the way I did this, I put application process as a check on the courts, could have been a check on Congress. I arranged it in a way that would look nice on the diagram. A lot of the things here could be in different places, but it works visually to arrange it this way. The states ultimately have the ability to, I'm gonna, if it's okay with you, stand up so I can actually see my slides over there while I talk. The states ultimately have the co-equal power with Congress to propose an amendment to the Constitution, and the convention is the route that they have in order to do that. They can use what James Madison called an explanatory amendment when, as my partner said, they were talking about the
Alien Sedition.
The Alien Sedition Acts, thank you. Next, there's the state's power over the delegates, and again, my colleague Richard talked about the direct power that states have over the delegates, and the way they use that in the New Hampshire Convention, for example. If you look at Black's Law Dictionary, there's a definition there for instructed delegate. There is no definition for instructed representative. The Supreme Court has been very clear, representatives cannot be instructed, they're free to vote however they wish. Delegates are a separate thing. Next, we're going to look at the checks that Congress has over this process. First, they have the power to call the convention. There are currently, if you look at the House Clerk's website, there are about 75 different calls for convention that Congress has actually counted. They come from, I tallied them all up myself, 36 different states. If you could take some from pile A and some from pile B, we would have a convention right now. We know we can't do that because there's no more than 26 that have been counted by Congress. There's 2 they haven't counted. There's no more than 28 on one issue, which is why we know we don't have a complete application, and so the obligation for Congress to call a convention has not been triggered. Their control over the delegates, which is the mode of calling the convention. Just as Congress would not send, the mode of ratification, just as Congress would not send something onto the states if Congress passed an amendment without their required 2/3 vote or did something else that was improper, nobody thinks that they would send that amendment onto the states. Similarly, if the convention does something that's not proper, if the convention is calling for an amendment that's not within the limits that are prescribed, Congress is just not going to send that onto the states. Next, there's the power of the courts, and that's the power to regulate. There have been dozens of bills in the last 50 years, or I think 70 years now, talking about regulating Article 5, and pretty much all of them have been entirely uncontroversial. They've been introduced by people like Orrin Hatch and people like Charles Schumer, who introduced one was a young congressman in the 1980s. And the Congress may or may not regulate it, but if they do, all of their proposals have been entirely uncontroversial on the subject. I know that's unusual. Next, there's the checks that the delegates have over this process. There's formulation. As my colleague pointed out, there's 3 steps: determination, formulation, and ratification. The states don't have the ability to all get together as states to write a convention. The tool that the states have to get together is the convention itself, and that's where the actual writing process takes place. The delegates themselves are tasked with writing an amendment that responds to the application that the states have called for, that does what it should do, doesn't do what it shouldn't do, and has the overwhelming popularity to meet the very high bar of ratification by 38 states. There's the delegates' check over Congress, and again, this is one, could have been a check on the courts, could have been a check on Congress, but it fit in the chart better if I put it here. Which is the delegates, as a tool for the states, have the ability to actually change, to propose an amendment to change the Constitution. That's the tool that the states have. Instead of Congress using that tool, that's the tool that the states have to go that route. And next is the delegates' check on the courts. And here again, it could have gone in different places. The delegates are chosen for a single purpose. Eli touched on this a little bit. You have this issue raised in an election. And when you have such incredible attention like you do at the presidential level, money does not have the same influence over that election as it does. It can actually hinder it. So when we're electing delegates for the single issue of ending Citizens United, that is an election where we actually will send delegates to the convention for that purpose around the country, and where they can actually win and compete against even better funded opponents. Next, we're going to look at the powers that the courts have. Seth was asking whether or not there's any way to force Congress to act. Well, there actually is. There's the Declaratory Judgment Act. Congress is free within certain limits to make their judgment about the convention calls, but that's why we have in our resolution what we call the daisy chain, which is a list of all the calls that are part of this same application, to ensure that we have one cohesive application with 34 states on it. So it's beyond question when it gets to Congress that this is a single application to call for a convention. If Congress does not do that, there's the Declaratory Judgment Act, which is a procedure, and hopefully we'll get into some of the cases involving it. It's a procedure where the courts can make it as if Congress has acted, even if Congress refuses to do so. And then there's the court's power of invalidation. Now, again, this terms like judgment and invalidation, they can, to some extent, they could be interchangeable. Again, I just use them to make it flow neatly on the chart. What the correct term is depends on details that are beyond the scope of what I'm talking about. But for these purposes, invalidation, just like Congress, when the states use their amendment powers improperly, the courts can and will step in, and the courts have numerous times stepped in when states have used their Article 5 powers of ratification improperly. And finally, there's what I'm calling injunction, but again, what the legal term is would depend on details of the case. If the delegates do act beyond their limitations, then the courts can step in for that. And there was a great example, when you're in Florida in 2008, when you're looking at, I think it's Ford v. Browning is the name of the case. When you're looking at different conventions as precedent for an Article 5 convention, it's important to note where they are and are not instructive. There's been hundreds of state constitutional conventions that have been called in this country in the last couple hundred years. And they're instructive for various purposes, such as how delegates will work. But states generally, when they're calling constitutional convention, it's a true constitutional convention that doesn't have limitations. Because when states want to propose a specific amendment proposed by the people, they tend to do that through a referendum. Florida is the one exception. Every 20 years, they have a true limited convention to talk solely about budgetary issues. In 2008, they had such a convention. It met. There was a reasonable disagreement among the delegates, where the delegates thought that their powers included some elements that were related to the budget, but weren't strictly on point. And there was a group that said, no, that's beyond the scope of your powers. And they weren't running away. It was a reasonable interpretation of their power, but it went to the courts to decide whether the delegates were right about their interpretation of their authority. And the court found that in some cases they were not right and did not send those on to ratification. The image I want to leave you with is this safety net, the way we know that this process can be limited. Thank you very much.